Summary on wills, but before we go there, let's just review the three basic estate plans that you could have. Number one is you can do nothing or procrastinate forever, which gets you absolutely nowhere except probably in a probate court, so that hopefully is not going to be your option. Number two, you can go with a will-based estate plan where a will be the primary document that will administer your estate. Or three, you can go with a trust-based estate plan where the trust is the primary vehicle. So let's take a look at wills. A will is a legal document that can be handwritten or typed, but it must meet certain legal requirements in order to be valid. When you die with a will, you have died testate, which means with a will. A will is only a death document, which means during your lifetime it has no legal effect whatsoever, and it is your last will that controls. A will should cover such things as who's going to be your executor. This is the person who's going to administer your estate. This could be a spouse, a child, a good friend, but if you don't name who the executor is going to be, a judge might have to do it for you. If you have minor children, then naming a guardian of the person for the minor children is extremely important so that we know who's going to raise these children until they become adults. If you want to put funeral, burial, or cremation instructions in your will, you certainly can, but you don't have to. And ultimately, we hope to see in a will a distribution of all of the assets that would go through a will. And the distribution then would include who is supposed to receive something, what is it that they're supposed to receive, how is it to be received, and when is it to be received. So all of those aspects are extremely important. So we know who's supposed to get what and when, but then it becomes how. How are these assets processed? And when you have a will, this generally will require a court probate proceeding to pass the assets from the deceased to the living people. We saw that with Whitney Houston. She had a will, and her estate is in the LA County Superior Court, where we can then publicly look at her probate file to see her assets and her debts and who's going to receive her assets. So probate, if you haven't been experienced to it or know what it is, we invite you to go see our probate video. But probate is a court process that is very public and time-consuming and costly. So if you do want court involvement and judges in your estate, then a will may be exactly what you need. But if you don't want to probate and try to keep the court and judges out of your life and the publicity and the time and the expense that goes with the probate, then you should consider a revocable trust, and we would invite you to view the trust video on our website.